Good afternoon. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland's UM Ventures. I'd like to extend a warm welcome to everyone who joined us today for our next installment in Startup Fundamentals Workshop Series, both live webinar audience and those watching a recorded version on our Startup UMD YouTube channel. This workshop series is offered by UM Ventures in collaboration with MTech at the Clark School of Engineering and Dingman Center for Entrepreneurship at the Smith School of Business. To everyone attending the live session, please feel free to submit questions using the Q&A function, which is usually located at the bottom of your screen. This session is recorded and will be posted to our YouTube channel, so if you wish to remain anonymous, you can submit your questions anonymously. Just there's an option to click to submit it that way. So today's session will focus on company formation and what documents do you need to get your startup going, which is a very important topic. And I'm very pleased to introduce today's speaker, Mark Ehrman, partner with Quarles & Brady Law Firm. Mark has over 20 years of experience working as a corporate services attorney, has seen all of it, mistakes made and mistakes to avoid. We're very fortunate to have him with us share his time. So thank you so much for your time and for your expertise to discuss such an important topic with us. So the microphone is all yours. I'm going to mute my mic and stop my video, but I'm here in case something else comes up. And I'll help with the Q&A as well. So.
Hey, thank you very much. And good afternoon, everybody. I'm sorry we can't be in person, but I'm happy to be in front of you and talking about some basics on corporate formation. As was mentioned, I'm with Quarles & Brady, and Quarles & Brady is a national law firm. We have around 500 attorneys spread out over 6 states, 10 offices. I'm a member of our business law group, which means I focus my practice on working with companies. I do a lot of M&A transactions, private equity work, and also spend a fair amount of time in working in the startup space, where I represent startups, investors, and research institutions in the startup arena. I'm going to focus my presentation today sort of on 3 main topics. The first is kind of a general discussion of types of entities you have when you're setting up a company. Then I'm going to turn to typical documents you see, which I call governing documents related to a company. And then lastly, for those that might be interested in getting equity or financing, I'm going to talk about the investment documents. So if you turn to the next slide, please. Next slide, thanks. So on this first slide, I kind of outlined the different types of entities we normally see. And for startups, it's really either C corporations or LLCs. A C corporation is a normal corporation that everybody's kind of aware of. Most public companies, I think all public companies, are C corporations. They're well established under the corporate law. That's probably the most common type of entity we see when startups are formed. I'll mention briefly S corporations. We don't see that much in the startup context. And for a variety of reasons. The next most popular is LLCs. That stands for limited liability company. And there are some benefits to having that over a corporation, which I'll touch on. But you do see other types of entities, for example, nonprofits, and also a relatively new entity called a benefit corporation, which is really a for-profit company that is trying to do benefit to the public. We're seeing more and more of those. And then you also have kind of common law partnerships and legal partnerships, which I won't really get into because we don't typically see those in the startup space. So if you can turn to the next slide. I'll start off by talking about the C corporation. That, as I mentioned, is the most common type of company we see. The downside of that company for most people is it has 2 levels of taxation. What I mean by that is when the company makes money, you have a corporate tax that's payable by the company. There's been a lot of talk, in the press recently about, potential changes in the corporate tax rate. But the corporation itself pays tax. And then when the money is distributed to the shareholders, they get taxed on the distribution. That's unlike S corporations or LLCs, which I'll talk about in a second. If you're going to get outside financing from a fund, like an angel fund or a venture capital fund, you typically see that they like to use C corporations. And the main reason for that is that they don't like the pass-through tax treatment that you get as or they don't like the pass-through tax treatment you get if you're doing an LLC. So they want to have a corporation in place to prevent that. So if you still want to use an LLC as an investor, you've got to create a company in the middle called a blocker, which can serve the same purpose, but most investors typically like using C corporations. And I'll mention that in a minute as to the nuance of that. Corporations have been around for hundreds of years, and they're well established under the law. Each state has its own corporate statute. I'll mention for a second that Delaware is the most popular state to set up a company in. And the reason for that is that years ago, that the founding fathers of Delaware wanted to be known for as an expert in a certain area. And so they adopted the Delaware General Corporation Law, which has been kind of copied in most states. Most states have similar laws, but Delaware is still the most common state. So if you set your company up in Delaware, there really won't be any question if you're using investors or outside parties, because they know what the Delaware law is, and it's the most readily understood corporate law. The second, probably most popular place to set up your company is the state where you're located. So if you're located in Maryland, you would use, a Maryland company. If you set up a company in a state that's other than where you're located, you will have to qualify as a foreign company to do business in the state where you're located. And that's just an extra filing fee that's required with the state. So if you turn to the next slide. So I'll mention briefly S corporations. As I said, they're really not popular in the startup context. And the reason for that is there's limitations on the types of entities that could be shareholders. You can't have companies or funds be shareholders. It's typically limited to individuals or trusts. So as a result, they don't work well if you're getting outside capital from a third party that's not an individual. They do have the pass-through taxation, meaning that there's no tax at the company level that's taxed when the money is distributed to the shareholders. And as I mentioned, they're really not in use when you use venture funds. So on the next slide, please, I'm going to talk a little bit more about LLCs, which is a second type of entity we see. And I think the benefit of using an LLC is it gives you the most flexibility up front. And by that, I mean, there are some things you can put in your agreement among your founders, which I'll touch on, that is really different, slightly different, or varies from the kind of the state law concept that you have for corporations. LLCs, each state has its own LLC law, but they tend to be a little bit less restrictive on the types of agreements you can put together for your shareholders. And so we see a lot of times people setting up the LLCs initially. It does have the pass-through taxation, meaning that if you elect partnership tax treatment, you don't get taxed at the company level. You get taxed when the money is distributed to the individual shareholders. And for those people that are getting money from angel investors as opposed to funds, angels don't mind LLCs. In fact, they kind of like it. They like having the direct tax flow into their individual income tax. The one advantage of an LLC over a corporation is if you start out as an LLC and later decide you want to have an outside investor that's going to require you to become a C corporation, you can convert to a C corporation without a lot of problems. It's much harder to go the other direction, converting from a C corporation to an LLC. LLCs under the law it's kind of a bifurcated structure. So they have the limited liability protection. They have a liability protection of a corporation, meaning that you're not liable, no member's liable for the debts of the company, but they have the flexibility of the partnership tax treatment without the second level of tax. So that's kind of a quick summary of the types of entities we see when we're working with startups. So if you turn to the next slide, I'm going to now kind of turn my attention to some of the documents you'll see when you're setting up a company. And before I get directly in that, I'm going to put on this slide kind of the hierarchy of what you see govern a company. And this is really whether it's a C corporation or an LLC. So first of all, you have state and federal law. As I mentioned, each state has its own law on corporations and LLCs. And so you need to understand what those are and what provisions those are. And some of those provisions can't really be changed by agreement. And then you also have federal law. Most federal law, like for example, the Internal Revenue Code is a federal law that would apply to any company, regardless of where it's set up. So you need to understand the state and federal law that's going to be applicable to your company. The next level of document you have is an article or certificate of incorporation, and that is the document you file when you create the company. And so if you're setting up a Delaware company, for example, you file a document in Delaware, which says a number of things. It's first of all got your name, and you can't use a name that's already been used in that state. It has the purpose of the company, and generally you can have a very broad purpose. You have to pick a registered agent and a registered office. And the reason for that is once you become a company, there needs to be a contact person and a contact place where people can serve you official notices. So you put that in your articles of incorporation. And then if you're a company, you might also put in the number of shares of stock that you have authorized, which is typically just initially common shares. And I'll touch a little bit more on that in the future. And then you have, if you go back to the slide, go to the next slide. Sorry, skip back. There you go. Thanks. Then the next main agreement, or I guess maybe the first main agreement you'll have that is kind of a legal document is the equity agreement. And if it's a company, if it's a C corporation, it would be called the shareholders agreement. If it's an LLC, it would be called an operating agreement. And that is the agreement among the founders, and it'll set forth certain things, which I'll get to in the next slide. And then if you're going to have financing, you're going to have investment documents, and I'll spend a little time on each of those. So let me turn to the equity agreement, which is up on the slide now. As I mentioned, that's probably the first document other than the articles, which are more of a form-based document that you'll need to worry about if you have more than one individual owning equity in the company. And the reason for that is when you think about it, you need to establish what the agreement is among the founders. So an equity agreement would do things like determine who's contributing what to the company. Some people might put in cash. Some people might transfer intellectual or other property. Some people might provide services. But the equity agreement will establish what everybody's contributed and how much they own of the company. And it's important to have that because I've had actually a situation where there was a series of operating agreements, and when you added up the percentage of equity that was held by the shareholders, supposedly it was over 100%. So that obviously doesn't work because you can't have more than 100% of the equity of a company. The next thing an equity agreement does is it establishes transferability restrictions. And so if I'm a partner in a company, I'm not going to necessarily want to have any of my other partners sell their interest to a third party. And so instead of just putting an outright restriction on that, which is not really favored under the law, we provide in these agreements that there's going to be a right of first refusal and a right of second refusal. And what I mean by that is if I want to sell my shares in a company I own, I've got to give notice to the company, and then the company has the right to match the offer I get for my shares. If the company can't or isn't able to match the offer, then typically the other holders have the second right of refusal to match the offer. And that really prevents third parties who are not part of the initial ownership group from being involved in the company. The next thing, and it's related to what I just talked about in the equity agreement, is a termination provision. And so if you have someone, let's say you have three partners and one of them decides they don't want to be involved anymore, you don't normally like to have that third person just be a passive owner. So you'd like to have the opportunity to buy those shares back. And so we put in the equity agreement, again, a similar provision that if someone leaves, they have to sell their shares back to the company. And that can be typically at either a formula value that's based upon some percentage of earnings. You could do an appraised value, you could do a book value, some scenario where they sell their shares back. Again, normally with the company having the first right of refusal and the other shareholders having the second right of refusal. The next thing the equity agreement does is it sets forth some operational procedures. So if for example, you have, you need to determine, how often you want to meet as equity holders, what type of notice you want to give. You can provide that the notices, that the meetings can be held virtually, which is a common thing now, that you want to be able to have a Zoom meeting and have it be an official meeting without having to meet in person. So it sets forth those type of operational procedures as to how the company will be governed. And then it establishes approval thresholds. So in the absence of any other provision, typically a majority of the shares or equity of a company could determine how a company is managed. But if you have a higher threshold, what's called a supermajority threshold, then you might say somewhere between 60 and 80% of the shares have to prove something before the company can do it. And the things you typically would put under that clause would be material things, like, for example, buying and selling real estate, making an investment in a third party, selling an investment like in a subsidiary or an affiliate, incurring debt over a certain level, selling the company, bringing in new partners, things like that. So you'd want to establish whether there are certain things you want to have that require a higher percentage than simple majority in the document. And then the last thing you would typically put in the equity agreement is sort of liquidity provisions. And I'll talk more about that in a few minutes. But what happens when you decide to sell the company? What's the approval? What's the approval threshold? How it occurs, and who governs it, and what happens to the money that comes in. So if you go to the next slide, please. So beyond the equity agreement, which is the first main one, I put up on this next slide, I guess, 4 other categories of agreements we typically see in working with startups. And they're sort of self-explanatory, but I'll get into a little bit of detail on each. So you have NDAs, those are non-disclosure agreements. Those are important because if you have a company that has some confidential information, you want to make sure when you're providing it to a third party that they don't go out and use it or copy it or anything else. Your IP agreements would be things like a license agreement you're getting to start your company. It could also be an equity agreement that you give to the university if they're also taking equity at the time. And then if you're having outside investors, there'd be the investment documents. And there's generally three main documents, which I'll cover toward the end of my talk. And then lastly, employment agreements. The law on employees is fairly extensive in every state. So every state has a very broad kind of employment law. Less so under consultants. So when you have a consultant, that's really a contractual relationship. So you need to make sure if you have employees or consultants that you understand what their duties are, what their compensation is, and how they can be terminated or not. So if you turn to the next slide, I will touch on non-disclosure agreements. I've seen a lot of forms of non-disclosure agreements over the years, and the main thing that I would say on these is that in order to be enforceable, you want to make sure they're limited in scope and time and that they're reasonable. And the reason for that is courts have typically said if you have an overly broad NDA that goes on forever or is just too broad in scope, it doesn't carve out certain exceptions like stuff once the material becomes public, it doesn't apply, then they won't enforce it. And if they don't enforce one provision, they typically throw out the whole agreement. So when we're doing NDAs, we try to limit the time period of an NDA to 2 years past whatever time period the agreement is. 2 years is generally in most states kind of accepted as a reasonable restriction. You can go a little bit longer in a sale of a company context, but 2 years is generally the scope. And you want the time period. You want to make sure, like I said, that the scope is reasonable. Trade secrets is a little different animal. A trade secret is something that is secret. You've taken reasonable steps to protect the secrecy, and it derives independent economic value from not being known by a third party. And for trade secrets, there's really no time period that you have to protect those on. You can protect those forever as long as they really are a trade secret. I think a lot of people assume they have trade secrets, but they're really not trade secrets because either they're not protecting them properly or they really aren't as secret as they think. And the classic example that everybody uses on a trade secret is the formula for Coke. The actual formula for the syrup has only been known, I think, by a handful of people in the history of Coke. And it's limited to when a person retires, then some other person gets access to it, but it's kept off site and nobody can really get access to it other than that individual. So that's a classic example of a trade secret. So nobody can copy that. So if you turn to the next slide, I'll touch on IP agreements. And there's really kind of 2 main agreements that we typically see. The first is the license agreement. As I mentioned, if you're getting intellectual property, for example, from Maryland, they would give your company a license. And the license would typically have things like, what is actually being licensed? What is the grant of the license? What is the term? Is it perpetual? Is there a set term? are there certain milestones that have to be met to keep the license? And then also what would be the field of use, which is sort of the areas where you can practice that intellectual property. That's all spelled out in the license agreement. If the university is taking equity, they might also have an equity agreement or build the equity provisions into the license agreement. And some of those equity provisions I talked about earlier, would make their way into the IP equity agreement. The other main area of IP agreements we focus on is assignment, what I would call assignment of inventions agreements. And those are where you have an employee or a consultant who is developing intellectual property for your company. You want to make sure that they've assigned all the rights to what they're working on for the company to the company, so the company owns it. You can do that within the consulting or employment contract, but oftentimes you have those signed by every employee, even if the employee might not have it, his or her own employment agreement. And it's a good practice for companies, if you have a form of IP assignment agreement, to get those signed sort of as part of the initial onboarding process when you first hire employees, to make sure everybody's signed those. If you turn to the next slide, please. I'll touch on each of these in a minute, but if you're getting outside investors, there are typically three main documents that you'll be concerned about, and we help companies all the time kind of negotiate these. But the form of these documents, there's an organization called the National Venture Capital Association that has developed sort of preferred forms of each of these documents. And you can get those online. They're free to download. They're lengthy and there's a lot of legalese, but they're good in the sense that if you have investors like to use these documents, and companies feel comfortable using them because it's sort of language that's been pre-approved, for lack of a better word, and it results in kind of the state of the art on investment documents. So if you're using the investment documents and have one of the forms that is approved by the National Venture Capital Association, you'll find that those are pretty useful and good to have. So if you turn to the next slide, please. So on employment and consulting agreements, I touched on this a few minutes ago, but as I mentioned, when you have an employee, the law on employment is pretty clear. Most states have rules on when and how you can terminate people, and if you have to pay them any money. But when you do have, more than a couple of people, it's always good to have some sort of employment agreement, even if it's just an employee handbook that sets forth what the terms of the employment are, so that there's no misunderstanding on how and how someone is supposed to work for you. As I mentioned, when you have consultants, the law is less clear on that. So, and oftentimes consultants are working for more than one company. So you want to make sure you set forth the duties, what the scope of the relationship is, what the compensation is. And employment and consulting agreements are a good place to add equity incentives. In a lot of startups, they don't have enough cash necessarily to pay employees sort of the fair market value for their services. So employees oftentimes ask and want to receive equity in the company in the form of either a direct grant or an option to buy stock or some sort of stock appreciation rate, where they can share in some of the upside of the company when the company does well and the company is sold. So those are good things to have. And you can add those into the employment and consulting agreements. And it does help kind of ease people's maybe hesitancy to start, to work for a startup where the cash compensation may be less than they could make from a bigger company. And as I mentioned, employment policies are good to have because you want to make sure you have a good understanding of, how many days of vacation people can take, especially in the remote environment, is there a certain requirement to be in the office? Is it all remote? If you are in the office, which days are you there, and all those things, so that there's no misunderstanding when someone comes on board to work for the startup. So that's kind of a summary of the sort of what I call the governing documents. If you turn to the next slide, I'll get into the third part of the talk, which is sort of the financing your company and the financing documents. And I put on this slide sort of the three main areas that we deal with. The first is grants. I think a lot of people are familiar with grants. They tend to be just payments from a government source or some sort of program. And what's nice about grants is they're non-dilutive, meaning the company gets the money usually and doesn't have to pay it back. And the person and the company and the organization providing money doesn't expect to have any equity. Grants normally come with some restrictions, not all of them, but most of them do. And things like, where you can use the money, how you can spend it. Do you have to hire employees with the money? Are there milestones that you have to meet to get sort of the next round of the grant? So while they are non-dilutive, they're oftentimes restricted versus debt, which you borrow from a third party. That's typically non-restricted, and you can just use that for any expense of the company. Debt falls into two categories. And again, this is sort of obvious, but you have unsecured and secured. Secured simply means the lender has taken a lien on an asset of the company. So if you do have real estate, that lien would be a mortgage, which would be recorded in the county where the real property is located. If you have other personal property or intangible property like IP, there would be a UCC financing statement filed again in the county where the company is located that shows the third parties that someone has a lien on the assets of the company. Unlike grants, debt is a balance sheet liability, which means once that the company has to show that as a liability, and it affects the company's net worth. And then obviously the last is equity, which I'll talk about again, but that's when you're selling an ownership interest in your company in exchange for cash. So if you turn to the next slide, I want to touch on debt documents. The most common ones we see for startups is convertible notes. And what those are they are notes. They're where a third party, usually an angel investor or a series of angel investors, lends money to a company. And they get an interest rate on it. And then that money is either paid back at a certain period of time or is convertible in the equity of the company. So the way that works is, like, for example, if I'm lending $500,000 to a company, I would get a note back that says the company has to pay me $500,000 with interest. But then when there's a subsequent round of financing, usually it has to be over a certain level, something that they call a qualified financing. Then I can take my $500,000 plus interest and convert it into equity of the company that's being raised in the next round of financing. And these are attractive because the main benefit of a convertible note for the investor and the company is you don't really have to determine what the value of the company is at the time of the note is the money is lent and the note is provided. So in my example, if I was buying equity for my $500,000, we'd have to determine how much equity I get in the company. So if it's 20%, that means the company is worth, effectively $2.5 million. With a note document, you can really defer that decision until the next round of financing. Once outside investors come in, they can determine what the value is, and then your note converts at that value. Now, the two nuances with convertible notes are that they typically have a discount and they also have a valuation cap. So the way the discount works is, in my example, instead of converting $500,000 into equity, I get the right to convert a higher percentage depending on what the discount is. So I effectively convert at 80 cents or 75 cents on the dollar instead of 100 cents on the dollar. So I get more equity in the financing round for my investment than I did otherwise. And that's compensation for my taking the risk with the company and agreeing to lend the company money, when they're first starting out. You do see sometimes typical, like I said, debt documents where you have either unsecured or secured debt. My experience in getting money from like a bank is the banks will only lend if the assets support the note. So if you do have assets that have value, you might be able to get a loan from a bank. If not, you're going to probably have to have someone guarantee the debt, which in some ways defeats the purpose of having the startup in place to begin with. So that's kind of a quick summary of debt documents. If you turn to the next slide. So now I'm going to turn to equity. So when you're financing your company, I mentioned there's sort of three main investment documents that you have, but you also have a fourth document, which is the certificate of incorporation. I mentioned that earlier, but when you first set up the company, your certificate of incorporation is pretty straightforward. It's usually a couple of pages. Once you get outside investors, they're going to ask you to amend and restate your certificate to add a bunch of provisions which relate to the equity of the company. And the reason they do that is because oftentimes investors want to have a new class of stock. They don't just want to have common stock. They want to have preferred stock. And it's preferred in voting, dividends, preferences, and conversion rights. But if you've had several rounds of financing, you might have a number of classes of preferred stock. So you'll see sometimes you'll have companies that have raised, let's say, 5 rounds of financing. They will have Class A preferred that's issued in the first round of financing. Second round would be Class B, third Class C, Class D, and Class C. So you have 5 different classes of preferred stock plus common stock, and the certificate incorporation has to say how many shares of each class are authorized and what the rights are vis-a-vis the other shares and classes of stock. So when you amend and restate the certificate of incorporation, you typically have a lengthy series of provisions which will become public because, again, it's filed in the state where the company's set up. So let me talk briefly about preferred stock. So it's preferred by definition because it's preferred over common. So it's preferred in one area, could be preferred as in voting. So the certificate of incorporation will set forth how many votes each share of stock has. Normally for companies, you just get 1 vote for each share of stock. But if the preferred shares are convertible into a different number of shares, in other words, the conversion rate is not 1-to-1, they oftentimes get how many votes they would have had they converted their shares into common. So there are provisions which have unequal voting rights among the classes of stock. The certificate also talks about dividends. So with preferred stock with investors, they typically like to have a dividend, which is effectively like an interest rate on the preferred stock. And the dividend could range anywhere from 4% to as high as 10%. But that's an amount that is paid in addition to the invested amount. So if you have an investor who's investing $1 million at a 7% dividend rate, that's an additional $70,000 a year that will go to that investor when the company is liquidated. Now, with most startups, the company doesn't have to pay that dividend currently. It just continues to accrue, and it's added to the preference amount when the company is finally sold. And as I mentioned, preferences, when you have a series of classes of stock, it's usually like what I would call a last in, first out concept. So the last stock in would be the first stock out on the preference. So in my example, where you had 5 classes, Class E would come out first, then Class D, then Class C, etc. When I say come out first, I mean when the company is sold or liquidated, those investors get their money first before the other investors get their money. Preferred stock is typically also convertible, and this is kind of a nuance, which is I could spend a whole hour talking about this, but the way the preferred stock works in most cases is upon liquidation of the company, an investor has the right to either get its preference, which is the amount of money they put in plus that dividend rate that I mentioned accrued over time, or they can take their preferred stock and effectively convert it into common. And let's say that gives them more percentage of the company than, and their payment as a result of that would be higher than their preference rate, they would do the conversion instead of the preference rate. So for example, in my example, if you put $1 million and you have you could say 2 years of dividends, so you've got about $1 million coming out. If the company's valued, and let's say you can convert into 20% of the company, if the company's sold for a number that's higher than $1 million, you're going to want to do the conversion because your amount coming out of the company would be $2 million instead of the preference amount of 1,000,001. There are some situations where you'll see what I would call participating preferred, and that's not very common, but in those cases, a preferred shareholder would get both the preferred return plus dividend, and they would have the right to convert. So they sort of get a double dip on their return. That's not very common because it's sort of considered, the investor's sort of taking too much out of the company. So if you turn to the next slide. So now I'm going to spend the last few minutes talking about the 3 other main agreements you'll see when you have investors. First is an investor rights agreement. And what this is it has sort of 2 main functions. It gives an investor a right to have the investor shares registered. I think some people think if a company goes public, that all the stock of that company is now publicly traded stock. That's not true. The only stock that's publicly traded is a stock that's registered in that offering. Everybody else has stock in that company, but there are some restrictions on being able to sell it in the public markets. So what an investor rights agreement does is give an investor the right that if the company is going public, the investor can have some of its shares registered as part of that offering, and that's considered a piggyback right. And you do see those exercised from time to time. The other right that's typically granted is what's called a demand right. That's where an investor can come in and say, I'm demanding you, company, register my shares. We don't see that. In fact, I've never seen that actually implemented, because when you think about it, it's hard to force a company to become public without their consent. The second main topic that investor rights agreement covers is I have up here, information rights. And as a shareholder under corporate law, there's typically a limited amount of information you can get by statute. And the first is annual financial statements, and the second is sort of like a list of shareholders. But other than that, you don't really have any rights to get any information from the company. So an information rights provision gives the investor the right to get, monthly financials, oftentimes quarterly financials, certainly annual financials, budgets, projections. Sometimes they get the same materials that are given to board members, but they have a contractual right to get more information than they would just as a normal investor, or a normal investor under the law. So if you turn to the next slide, please. The second main agreement you have with an investor is a voting agreement. And that really is designed to get at how you're going to select the board of directors of a company. And the board of directors of a company is very important, because under the law, boards have a broad authority. They can be superseded by act of the shareholders, but generally boards are given broad latitude as how to govern the company. So you want to make sure you have a good board in place. And the voting agreement is a place where investors say, look, we want to make sure if we're putting in this amount of money that we at least have a seat at the table for the board. And oftentimes they'll get the right to designate 1 out of 5 members or 1 out of 7 members. And then other investors will have a right to designate somebody else. And then oftentimes the common or founders have the right to designate a couple of seats. And then the rest of the seats are open for outsiders. And the voting agreement spells how that works and who has to vote for it and how these directors can be removed. I think it is important to try to have some outsiders if you have a company, because outsiders tend to be more open-minded and less tied to the financial stake in the company, and oftentimes come from industry or other places where they've had experience in the same area of the company. Voting agreement will also talk about how you sell the company. I'll touch on that in a second. And there are other material matters, like, for example, if you have the supermajority thresholds I mentioned, since investors typically aren't party to that original equity agreement, they have similar provisions that they put in their voting agreement that says you can't take certain actions, certain material items without approval of a certain percentage of shareholders. And that percentage is often set so that the investors have some say in that process. So if you turn to the next slide, please. The last agreement I'll touch on is right of first refusal and co-sale agreement. And again, as I mentioned, because investors aren't subject to that original equity agreement, you want to make sure that there's similar provisions that govern the investors. And so that's put in this agreement. So if the investor or if another founder wants to sell stock, the company has the right of first refusal, and then the second right would go to the investors. So the investors have some say in making sure that the founders don't sell their stock, because once investors come in, they want to make sure the founders are tied to the company. The second main thing it does is give what I call preemptive rights, and preemptive rights are the right to invest in a future financing and maintain your share of ownership of the company. So if I own 10% of the company and it's raising $2 million, I would have the right to basically buy 10% of that offering or invest another 200,000 to maintain my 10% ownership. Now, when new money is coming into the company, the new investors typically want to be able to provide the capital. So they'll oftentimes ask the existing investors to waive those rights, because otherwise, if all the existing investors exercise their right, there wouldn't be any money coming in from the new investor. And having a new investor is oftentimes helpful, because you have often a lot of times a new board member and new new relationship that you want to establish for the company. The last thing this agreement does is provide bring along and come along rights. What those are provisions that allow the company to be sold as a whole. So if the company's doing a stock sale, you would really need, in the absence of these provisions, every stockholder to agree to sell his or her shares in that transaction. So what these provisions do is say that if we have a supermajority decide we're going to sell the company, then all the other investors have the right to come along, but we can also bring them along. That's why they're come along and bring along rights, and force them to be part of the transaction as a whole, and so that you can sell the company as one unit. And there's usually provisions that say that everybody has to be treated equally, at least as with respect to their class of stock, and they're subject to the same sort of contractual restrictions as everybody else in that transaction. Those are set forth in the right of first refusal and closed sale agreement. So that's a very quick run through of the material provisions we see in a company. And I've got several minutes for questions. Be happy to take those if anybody has any.
Thank you so much, Mark. This has been very informative, as always, and very information went from basic to complicated very quickly, but I'm hoping that's going to be very informative for everybody. If you have any questions, I'm sure this was a lot, but if you have any questions, we have a few minutes. At this point, you can either post them in the Q&A, or you can also raise your hand and I can unmute your mic. We have a raised hand. Go ahead, Rashid. You can talk. Let's see. Are you able to unmute your microphone to ask your question? There you go.
Sorry. Hey, Mark. Thanks for a great presentation. I just wanted to know if you're starting off as a C Corp or as an LLC. Do you have the same protections against personal liability as you would in a C Corp?
Yes, and I should have been more clear on that, but either a C corporation or an LLC gives you the liability shield, meaning that for corporate purposes or state law purposes, there's a separate entity that's liable for the debts of the company. And there's no personal liability that goes to the owners, unless obviously you were to sign a guarantee or something else. But if you create either an LLC or a C corporation and the company incurs liability, you would not be personally responsible for any of those liabilities, and that's why it's nice to, obviously set up a company, because if you just set up a business as a sole proprietorship, for example, then you're liable for all the debts of the company.
Yeah. And the second question I had is, I know you went in details about the equity agreement and the accrued dividends and all those things. For a startup, how important are having all these documents? Because some of them I might not have answers yet. Like, I would not have answers so as to how many shares of common stock I should be offering, how much should I be reserving for future investors, how much for angel. So that kind of breakdown.
Right. Yeah, that's a good point. So when you're first setting up a company, I usually tell people, whether you're doing an LLC or a corporation, just select sort of a basic number of shares to authorize. Let's just say it's 10,000 common, because you don't really know what you're going to need in the future. And you can always change it by adding to that. And so you just want to make sure that you have enough for the initial founders. And, the other thing you can do is if you have, let's say, 10,000 shares and you need, you can always do what's called a stock split, or, where you kind of create either more shares or less shares, so that you get to that number. But I usually tell people just to pick a number like 10,000 or 100,000, just do common and set up your articles that way. Because when you get outside investors or others that might be interested, they're going to tell you what they think it should change to. And so, for example, if you've got just common 100,000 common shares, and an investor says, we want to buy, $2 million worth of preferred shares, then you'll know you have to change the certificate to add to the common and also to create that new class of preferred stock. And as far as, which agreement you need, I think the main agreement you need is really just the first one I talked about, which is the equity agreement. Because, it's nice to have these other forms, but when you're first setting up the company, that might be the only thing you have just to get the company set up. Once you start then providing, confidential information, you can have a form of NDA, then you can have your form of license agreement, things like that. So you kind of go in the order, I guess maybe the order that I presented them in the talk.
Okay, and again, I just would like to know, how much do you charge for your services?
Right. So we have some flexibility. We have kind of what I would call for lack of a better word, a startup entrepreneurial package. So we'd want to kind of figure out the scope of that, but we would charge basically like a sort of a flat fee for getting the company set up. And we have some ability to, get most of that, part of that paid up front, and part of it could be deferred for a period of time. But usually it's in the neighborhood of, for like getting the company set up, for doing the equity agreement, and so, somewhere between, I would say, $5,000 and $10,000, depending on how much you wanted to, if you just wanted the equity agreement, it would probably be on the low end of that. If you wanted sort of forms of the other ones, it would be it would be toward the high end of that.
Thank you so much for
Sure.
going through.
Thank you for your questions. We have a few more questions that came into through the Q&A function. So one is, do you have a curated one-pager for all of these documents that a startup needs? Would be cool to see the documents on a timeline in terms of when they typically come up into play for a startup.
Yeah, we don't really have a one pager and we do have obviously forms of these we've used, but each one's a little unique to the situation. As far as timeline, I would say, when you first get the company set up, you certainly need the certificate, because you need to get that file to set the company up. And then you would need the equity agreement probably very soon if you have more than one shareholder. The other ones are maybe down the road a little bit, but my experience has been usually within the first year of your company, you've at least covered the kind of the main agreements, the NDA, the IP agreements, and then the employment or consulting agreement. But we do have forms we've used for these. Usually, they're a few pages, but they're really kind of ones that you can use. So if you have, like, let's say, several employees, you might have sort of one similar employment. You wouldn't necessarily have like separate looking employment agreements for every employee. You just have them all sign the same one. Maybe just have different compensation, different duties in there.
All right, thank you. The next question is, what is the advantage of directly going C corporation versus LLC and converting later to C corp?
Yeah, converting later from an LLC to a C is not a big deal. So we see people that if they think they may never need outside capital from like investors, like an investment fund, then they might go the LLC route and then later convert to a C corp. But if they know for sure that there's going to be, let's say it's a kind of it's a drug discovery company that they know that they're going to have outside investors, then oftentimes they just bite the bullet and do a C corporation up front, so they don't have to do the conversion later. The other thing I'll mention on the some people get hung up on the two tax versus the single tax. Obviously, if the company's not making any money, there's no tax in any event, because whether it's one level or two level, until the company has a profit, there's no tax to be paid generally, and the company can build up losses, which can offset that tax for many years. So you'll see startups that have numerous millions of dollars of net operating losses that they can use to offset their corporate level of tax in certain situations. So I guess I don't really have a strong preference either way. I think C corporations are slightly simpler just because the documentation is a little simpler. But other than that, I think each one can serve its purpose.
Thank you. And one more question. When it comes to trademarks, what kind of process does a company have to go through to apply?
Sure. So for a trademark, there's different types of trademarks, obviously. So for a federal mark, you would need to file a federal trademark application with the Patent and Trademark Office. And for that, there's typically, I want to say for that, we would typically charge somewhere between, let's say, $1,200 and $2,000. But a chunk of that is the filing fee. There's a fairly significant filing fee for that. You get several $100s. And the advantage of doing the federal mark is that then you are protected for anybody else wanting to use it sort of going forward. But it's limited to whatever services or things you put in the application. So if you had a mark and you can combine sort of the name and the trait and the logo, let's say, as part of one mark, you could actually file two different marks if you wanted the logo and the name separately. Most startups don't do the two marks because it's expensive and you don't need that protection. A company like McDonald's obviously has a trademark on the golden arches, but they also have a separate marks, a number of them on the word McDonald's. So they have, you can neither use the arch nor the word McDonald's in any capacity, but they spend millions of dollars a year on their trademark protection. But that's a long way of saying for trademarks, you typically would file a federal document, and then once you file it, you get rights going forward from there. You can have what's called state law trademark rights, which just by using a name, you get rights under your whatever state you're in. But if someone else isn't aware of that, they could be using it in another state, and you wouldn't be really able to enforce that necessarily. So that's why a lot of people go with the federal trademark application, just to get everybody on notice for that.
Thank you so much, Mark. Let's see, do we have any more questions? I don't see any more questions. And looks like we are almost at time. Let's see, this one's done. We're almost at time, so thank you so much for spending your time with us, and thank you to everybody who attended, and especially to those who asked really good questions. I will follow up with the link to the live workshop when it's posted to YouTube, so you can watch it again. And again, thank you so much, Mark. This has been a fantastic session.
You're welcome, and you'll see my contacts up there on the slide. So if anybody has follow-up questions you didn't want to ask in the group, feels free to shoot them out to me, and I'll be happy to follow up.
Thank you so much.
Thanks. Have a good day, everybody.
You have a great day as well.
Thanks. Bye.
Bye.